For a will to be valid, a person must intend for it to be his final will when he executes it. What if someone executes a will and then marks it up a few hours later? Does that prove the person never actually intended the document to be his will? The Wisconsin Supreme Court explored this question in Re Estate of Beal. Howard Beal lived in Wisconsin and had 3 minor sons. Beal had his secretary type a 14-page will that disinherited his youngest son, 10-year-old Thomas. Beal flew to New York City, where he executed the will in front of several friends, with Beal and 3 witnesses signing the last page. That same day, either before or after the will was signed, Beal wrote a letter asking his secretary to make changes to 2 of the original will pages. These changes didn't impact the distribution of Beal's estate. Beal then flew to Moscow, and the secretary typed the 2 revised will pages. After the trip, Beal asked his secretary to retype the revised will pages on a different typewriter so that they would match the original will's pages. Beal died shortly after that, before the revised pages were retyped. The original will was submitted to probate. Through a guardian ad litem, Thomas contested the will's validity. If the will wasn't valid, then, under the laws of intestacy, Thomas would inherit part of his father's estate. Thomas claimed that Beal hadn't intended for the original document to be his final will when he signed it, which was necessary for it to be a valid will. Instead, Beal had executed the will only to obtain the witnesses' signatures, intending to swap out other parts of the will whenever he wanted. As proof of this theory, Thomas pointed out that Beal had changed the original will's pages either shortly before or shortly after signing it, which wasn't consistent with intending for the original version to be his final will at that same time. Further, Beal had tried to match the new changes to the original pages, which was consistent with treating the original will as merely an interchangeable shell. The probate court determined that Beal had intended the original will to be his final will when he executed it, that Beal had changed the 2 pages after the will was executed, that those changes weren't effective, and that the original will was valid. Thomas appealed to the Wisconsin Supreme Court.